Yes, no, sir.
My lord, they were supposed to place the record and
What is your decisions that you are relying on?
my lord, the intention of the here, if your lordship permits me, lord, on the body of the judgment, I can mark the relevant paragraphs. Otherwise, I'll just tell it.
Just give to me. You can mark it there also, no problem. Just give me an idea what you are trying to refer to. Then
My
we'll
lord,
ask Mr. Patwari.
Yes. My first submission is that, my lord,
Huh.
My lord, I'm sorry, my lord. As per page 9, there is another file, policy file. That policy file perhaps will also be required. my lord.
That is for them to produce. If they have not produced, I can't help it. Inference I'll draw against them. We'll come to that. We'll come to that.
my lord, my first submission is that if the appointment is in excess of vacancy, notified vacancy, my lord,
We have got that. Those are general
Yes.
submissions.
These
that
are-
you can incorporate in your written arguments.
yes,
But tell me the judgments that support you. That
regarding
delay,
yes.
delay part, what do you have to say?
Now, my lord, the first point of time, the judgment that came, that was a long time back, my lord, 74 R.S. Devdar case. There, the Honorable Supreme Court said that if it curtails any of the fundamental rights, because the fundamental rights cannot be bartered against any of the considerations.
There is no violation of a fundamental right
No.
because you were serial number 4 and he was serial number 2
No,
in this
I-
election process. This is
I-
not promotion. This is not promotion. This is pure and simple direct recruitment. Projections made here and there, we are not going into that. Records
No, it-
also demonstrate that this is a direct recruitment.
No, my
We'll
lord,
stick to that.
my lord, just for a moment. Our case has been that since it has been made against the promotional quota, because on that particular day, there was no.
That's for you to argue.
No,
but what we have found, there is no material for that.
No, my lord, I mean, going by the nature of pleading, my lord, I am making this.
That we have asked Mr. Kayal to clarify because the records, if it speaks in a particular manner, no amount of pleading can undo that.
Yes, that's
MS Gill and all those
But
things
yes,
will come in.
But assuming for a moment, my lord, that if the finding, your lordship comes to this finding, that ultimately this has been eaten up. I mean, the post has been eaten up from the quota of promotion. Then, my lord, consideration is one of the factors.
You show me that this has been eaten up from the quota of promotion.
Well, that last day also I said, my lord, 11 posts are totally in total. There are 11 posts.
So at that point of time, the rest
Rest were occupied by the direct.
promotees, 2 were occupied by
Direct recruits.
direct recruits and the others were occupied by
No, others were. I mean, the promotion quota, my lord, the posts were vacant.
vacant.
Yes, on promotion quota, the posts were vacant. So, operating the, recruitment rules, my lord, 87% of the posts had to go to the promoting quota, 17% only to the direct recruit. And if 17% is operated on 11 number of posts, total cadre strength,
9 plus 2.
then 9% remains for promoting quota and 2 for
So
direct.
as of 2011, how many promotees were in place?
As on 2011, there were only 2 direct recruits, no promotees.
All other 9 posts were vacant.
9 were vacant.
So why was this 9 posts not filled up till 2024?
2024.
2024 when you were
2024,
promoted.
they first made the appointment.
So what is the reason that these posts were not filled up from?
Well, that has not come on
And
record.
what is your grievance against that? That vacancies are there, you are not filling up.
Now,
Have you raised any grievance in that committee?
No, that we did not raise primarily for the reason, my lord, let me be very frank to the honorable court. The recruitment rule also requires a residency period in the feeder cadre. So unless and until the candidates serve that feeder cadre, I mean the residency period in the
On
feeder.
that day, there was no promotee eligible for no person in the feeder cadre who had the residency.
Yes, 2011, my lord, residency period was neither I had the residency period nor he had the residency.
And what is the criteria for promotion?
That is, my lord, I'll just refer it from the rules itself. Assistant directors of TD development with 5 years of regular service in the grade.
I know that, but what is the criteria? Merit come seniority, seniority come merit. What is the selection post? What is it?
Selection procedure is, Millard. It's merit come seniority.
Merit come senior,
Sorry, it's seniority based.
seniority.
Seniority
Sure.
based.
Seniority based.
Seniority based. Promotion quota, I am saying of promotion. quota.
Seniority.
Seniority based. So on that day, 2011, Millard, the persons were not there. I mean, in the feeder cadre, the persons were not there. So therefore, Millard,
So
my,
when did the persons in the feeder cadre become eligible? Because it's only after you become eligible, he will become eligible.
yes,
So when did you become eligible?
I became eligible in the year 2014. Because my appointment was 2009. And his appointment was 2011.
So 2014 to 2024, in spite of vacancies being available,
Yes, they,
no exercise was carried out.
no,
So your fundamental rights were violated. Why did you not make a prayer in that line here?
no, Millard, that is why here, Millard, in this writ petition, Millard, here we have said that since the promotion quota was eaten up, therefore my fundamental right got violated, and that's why I am before the court.
So if that be so, that there was a promotion exercise carried out, but you were not given a consideration therein. It is there only that your rights
Yes,
in terms of Ajit Singh and all those
Yes,
series of
yes.
judgments will come to be violated.
yes.
But there is no promotional exercise carried out.
No, Millard, our case has been based on this premise that since there was no quota in on the direct recruit cadre, so naturally this had to be taken as a promotion. And in fact, Millard, although their records are revealing now something different, Millard, but in the service book of the person concerned, Millard, it is written as promotion. I have just got a copy of the relevant page, Millard. If your lordship permits, Millard, I can place it to your lordship. The service book also, Millard, it is indicated as promotion. And they submitted, the T board, statutorily, they are required to submit a report every year to the parliament. In the
Okay,
parliament
Mr.
report also
Doctor.
they have indicated is
Mr.
promotion.
Doctor, okay, we accept your plea that he was promoted. That is bad on two counts. One, there was no relaxation of his residency period.
Yes,
Two, this was done without considering the seniors in the cadre,
yes.
right? We interfere. So we'll call it promotion for your satisfaction. In 2011 goes. Now what? I can't direct for your promotion as of 2011.
No. Even I will not ask for my
So
promotion.
you
as of
will be
2011.
promoted in 2024. What you have done, it's there. It cannot be given a retrospective effect now.
No, Millard, if his promotion is maintained from 2000.
No, we can't maintain an illegality. We will interfere. What benefit will accrue to you? Other than he losing the promotion or a
No,
direct.
Millard, as on date, Millard, as on date, there are vacancies, Millard. Your lordship on that day asked me about the position, Millard. There are vacancies. And there was one misinformation on my part that I said that he is my immediate junior. That is not correct. In between me and him, there are 4 candidates. And out of them, 2 have already got promotion. In between me and him, respondent number 5, there are.
And they have no regrets with regard to the retrospective effect or the illegal promotion given to.
At least, Millard, none of them have approached the court. None of them have approached the court.
Now, why did you wait till 2018
Well,
of an incident of 2013? Now, show me that we'll have to ignore any
No.
decision of the Supreme Court.
Yes,
which
Millard,
says-
I am coming to that point, Millard.
Come to the meat.
That's
We'll
why, Millard.
Take care of the masala.
Well, Millard, that's why my first submission was that since it's a matter concerning my violation of.
We got it. We got
So
it.
therefore,
We got it. Let's keep it at that. Now you tell me.
Now, one of my pleading in the writ petition goes that this appointment is by means of a void order.
para, that second part of para 12.
Yes, it's a void order. Now, one decision I will rely before your lordship,
Hmm.
that says that if it is a void order, my lord, then limitation will not apply.
That's what I want. Show me.
My lord, if I can pass on this,
Give me the
Judgment to-
citation.
well, that is 92 Supreme Court, AIR 1992 Supreme Court 1555.
Party's name?
Party's name is, my lord, Shrist Dhawan versus Shaw Brothers. Sir, I am just passing on the printout. If your lordship will kindly come to paragraph 19, page 10. And then at page 11, about 20 lines from top.
Yes. Error in assumption. of-
Error in assumption of jurisdiction should not be confused with mistake, legal or factual in exercise of jurisdiction. In the former, the order is void, whereas in the latter, it is final unless set aside by higher court of competent authority or competent authority. An order which is void can be challenged at any time in any proceeding. Here was a case, my lord. It was challenged in a suit. There was an order passed by the customs authority levying some penalty. It was challenged in a suit, and the plea was taken that since it was belated claim going beyond the period prescribed under Article 14 of the Limitation Act, so the suit had to be dismissed. The suit was dismissed on that ground, and the matter went up to the Supreme Court. There, my lord, this question arose that whether it could be seen as a void order, and if that be so, irrespective of the bar in the limitation, whether the suit will be still maintainable. Down below, your lordship will kindly see. A permission granted under so-and-so, once permitted to attain finality, becomes unassailable on error in exercise of jurisdiction. It could be challenged later or in execution only if it could be brought in the category of a void or ultra-vires permission. Such invalidity can arise if jurisdiction is exercised by misrepresentation of facts, either about existence of vacancy or nature of premises. In other words, what attains finality in accordance with law cannot be permitted to be re-agitated or reopened except in the larger social interest of preventing a person from practicing deceit. Therefore, an error of jurisdictional fact which could entitle a controller to re-examine the matter in the context of 21 is same, namely fraud or collusion. Then the
Here, there is neither fraud alleged
No.
nor collusion
no,
alleged.
that is fraud or collusion, my lord. It is one aspect of the matter.
It is a misinterpretation of the provisions by the respondent authorities,
Yes.
right? So if there is a misinterpretation and you have not alleged malice against that interpretation, that it was made for favoring the private respondent by XYZ in the organization, and you have not made them party respondents.
No, I am not, I'm
So
not saying
how
that.
far can this court go? And now it might be a mistake of fact,
No, my lord, it is not a mistake of fact.
because they may have understood it in a particular manner at that point of time, maybe erroneous, but it's not, materials are not there to show, or I want you to highlight materials to show that this was done deliberately with mala fide intention to deprive you and benefit you.
My lord, as I understood from this judgment, my lord, the test is not what is the consequence leading to the voidness. The test is whether whether the order itself is void or not. There may be the consequences leading to the voidability or the voidness.
No,
of the
no,
order.
we'll have to look into that how that order had come, because it says whether that court had the jurisdiction or not.
Now,
These are aspects which are,
yes,
it is not, here in this case, the authorities had the jurisdiction to promote and also to demote
No,
a person.
here there is the catch. Authorities having jurisdiction to promote is only contingent upon the operation of the rules.
That's what I'm saying.
Dehold
They-
the rules, Milord, there
They
is no
cannot
authority.
do it. There, that is absolutely correct.
Yes, and
But-
on that day,
But if there was a misunderstanding of the rules,
no, if your lordship will go through, since your lordship has already gone through the note sheet,
that's
Milord,
what I'm saying.
note sheet makes it very much clear that the authorities were aware that how
No.
many posts are available on direct
No,
recruit quota.
what they were aware was when they were promoting him, they reckoned the 4 posts that had come in. While filing an affidavit, they have said many things. Guilt, we'll ignore it. But as of 2011, what was the understanding of the authorities? That say we have 4 posts more granted. One will go to the direct recruitment, and we require these people to man the new scheme. So kindly approve that we can promote, we can utilize that, and he's at serial number 2, we will give it to him.
That is
So
the-
that understanding
That
at
is-
that point of time, you had no grievance.
no, that is the jurisdictional error, Milord.
It
I
is not a jurisdictional error. It is a error of understanding.
My lord, I
Because why I say so, subsequently, while they withdrew that, they also came to
no,
this.
they withdrew it on my representation.
Okay,
In 2011, when the appointment was made, I filed a representation saying that look, these are the quota position, these are the things. How can you give him the
your
appointment?
representation is on record?
yes.
Okay, fine,
Yes.
fine, we'll
It's
look at
there.
it.
Then
Now-
they consider it and they withdraw it.
Now, have you also taken a plea that there were only 1 post advertised, you could not have gone for 2 posts? You have
Yes,
taken a plea.
yes,
So they accepted that plea.
yes.
They withdrew it. Subsequently, 2 years, there was nothing. That is the only period where Mr. Patwari is having some slippery ground. Now, in 2013, he, on his behalf, a legal notice is sent. Acceptance, offer, acceptance, finality. They understood it in a particular manner. Once we have offered, that means it has attained finality. And they gave it to him.
No, I am not, yes.
They gave it to him. Because I'll have to see both. They gave it to him. Now, that was the only reason. It is erroneous, but not actuated by any mala fide or any biasness towards him. It
At
was,
least I have not alleged.
you have not alleged, and records also don't demonstrate. Now, in this circumstance, a thing that happened in 2013, it validated something of 2011.
No, here the appointment also, this 2000, it is operative from 2013 itself. They did not give him benefit from 2011.
No, need not, because that they have only withdrawn. So if it is withdrawn, the 2011 appointment gets revived.
They say so in the order, but in effect, my lord,
We are not, consequence, we are not there.
no, in effect, even the.
He
even
will
in-
not get salaries from 2011, he'll get salaries from 2013.
Yes,
But there is no fresh promotion order in 2013. That is
No.
your argument also, right? The order is only of 2011. So we'll have to now construe the limitation from 2011 by default. Okay, when you challenge this matter, you will have to explain as to why from 2013 to 2018, you were maintaining an inertia. You were satisfied with the situation that was there.
no, 2011 to 13, when the order got withdrawn, my lord. Naturally, I didn't have any cause to agitate.
No, 13. That's why I'm saying. Effect is from 2011. By applying section 14 of the Limitation Act, we condone 11 to 13. That period is like it was litigating somewhere. We borrow that. From 13 to 15. No, first is 15. 13 to 15, what were you doing? You knew it on 13. It's not your case that you did not know about this thing happening in 2013. You knew about it. What did you do?
No, that is, my lord, howsoever lame it may look like, my lord, there is only one explanation in the repetition that 13, this revival came, and 14, the repetition before Madras High Court.
14 or 15?
14,
14.
14.
So
14
1
was-
year, 1 year, Still, there is a gap of 1 year.
Yes.
15, there was another milestone occasioning when that writ petition,
16.
sting of that 16,
16, that gentleman
Died.
expired.
you have not, at least I did not get it, made any statement that the death of that gentleman in 2016 was known to me only in 2018 before I filed this writ petition.
No.
So 15 to 18, another 3 years, you allowed this thing to
Remain good on record.
attain more solidification.
Yes.
Now you tell me, in this factual matrix, how will this go? Because it's not a question of delay now. Delay, we can ignore. It's a question of latches. It's a question of latches, and latches is serious.
No, that, my lord, I have on the day one, my lord, I have very
So
Right,
what
yes,
is
yes.
the material you have that even in spite of the delay and latches occasioning, a order void would still be permissible? This judgment will not help you.
No, this judgment is only for the purpose of demonstrating that if an order is void ab initio, then it can be challenged in, and not only this, my lord, my lord, the Honorable Supreme Court has gone to the extent of
And
saying,
your that para 12, that explanation why you did not come up, does not. Rather, it goes against you that you had knowledge of it, but you still did not want to challenge it. And the gentleman who challenged it, was he senior to you or
yes,
junior?
senior to me.
Senior to you.
He was senior to me, and eventually he also got his promotion.
So you were under the impression that even if the promotion of Mr. Patwari is interfered with, you will not get any relief
No,
because that person would get it.
yes,
So your cause of action to challenge that came up only in 2016 after the death.
after that gentleman died.
Can that unforeseen, what is that provision in the Contract Act? An unforeseen thing cannot be the ground to, what do you call it? No, not force majeure. Something which will happen in future cannot be.
Uncertainty happening.
So, Mr.
Practical-
Doctor, you will have to take me to that level,
My lord,
unfortunately.
my lord, on this aspect, my lord, I know, my lord, I am on a very sticky ground because
No, because
Because
if I don't
the-
come out of that, I can't just go and bring him down. I'll have to be satisfied because yesterday night also I was thinking about this. The erroneous, clearly erroneous, but I can't take it beyond erroneous. That it's void, but something that has been allowed to continue for such a long time, till 2018. And he is now in a different league altogether.
no, today, as on date, my lord, we are in the same cadre.
No. He is in a different league because he is there from prior to you. Even if I today interfere with it, it would be a violating because some rights have now accrued to him.
My lord, one judgment, my lord, of
Hmm.
course,
That's what I'm not getting the
one judgment.
thing
my
I
lord.
want from you.
Here was a case, my lord. It's a case from Bihar. Large scale appointments were made by the government. Ad hoc basis, master role, this and that, many times, many species of appointments. Those were made some in the 80s. By 1996, the government realized that there were so many illegal appointments, and many of these appointees.
What is that citation?
State of Bihar versus UNC.
Then the Supreme Court finally said Bihar interfered with those appointments.
Yes.
Then I think the Supreme Court has upheld that.
Yes.
Huh?
Yes.
Why do you go to, there is a recent judgment of the Supreme Court with regard to the Calcutta teachers recruitment.
Well, the day before yesterday only it has come.
That judgment, it's very clear that if something is void, they have even asked for
refunding
the salaries
Beyond,
with
Huh?
interest.
beyond repair.
With interest.
beyond repair. So that situation, unfortunately, is absent here. I've even thought about that. That Calcutta judgment, I wanted to see how it applies here.
Ballad, I checked it, but on the facts of this case, perhaps that will
But
not
the
work.
ratio that is there,
But
four principles.
But here, in this case, Miller, this Bihar case, Miller, the government, in between, they were also regularized. Not only appointed, they were also regularized in service. They had spent more than 10 years in service. Then, in the name of implementing a policy to weed out the illegal appointees, the government issued termination orders. Those were challenged in the High Court quashed the termination orders. Matter went to Supreme Court. Well, this principle.
Supreme Court, I think, has said that it's for the government.
No, Supreme Court has said that if the appointment is illegal and void, no matter of time, whatever you must have spent on the job.
Has the court also examined that if this challenge to the appointments were made after that delay of
Yes,
10
yes.
years, 20 years,
Yes.
and then whether the court could have interfered with that?
My lord,
I think the ratio here is
my lord-
that the government's power to undo something, it's always there. If tomorrow the T board comes up and takes up a plea that no, what we have done in his case is wrong, we are bringing it down. Maybe that delay, because I have not to consider that delay then. I'll only have to consider whether that action is proper. But when you are challenging it, qua your rights, you will have to demonstrate that the delay is not fatal.
so on that point, my lord,
My Lord Justice Ujjal Bhuiya's judgment in the case of Debojit
Debojit
Das,
yes,
it went up to the Supreme Court. Therein,
we were just
The-
discussing about it, my lord.
second round, I was there that side. The Debojit Das's appointments, there was a incident when it was challenged, the challenge was withdrawn. Like your case. Then there was a lull. Matters, the withdrawn, dismissed on the ground that of delay. Then I think after around how much?
9 years.
8-9 years, the government took a decision that no, we will re-examine. Same like Bihar case. On re-examination, the government said, no, these promotions are bad. There was a committee, that committee report was accepted by the government. He was brought back to the rank of assistant executive engineer. He went up to executive engineer, comes back to assistant
Assistant.
executive engineer. Then my Lord Justice Bhuiya in his judgment said, the question, because delay was, the delay was urged there because there was a challenge also. And he had also challenged these two orders. So there was a challenge to his order for promotion as superintendent. Then this court said, this is an action done by the government. The rigors that we have to apply when a belated challenge is made will not apply. And that matter went up
One
to-
sentence we were also discussing, scrambled egg cannot be unscrambled.
once come to. So this has gone up to Supreme Court, and the Supreme Court has very categorically in the last paragraph said, division bench set aside, learned single judge's judgment restored. I can't ignore that also. And that is pari-materia. That's a unique case
Unique.
wherein the delay, but the contrary view of that, which is facts, which is there in your case, if I apply that ratio, so which is also binding on me, I'll have to dismiss you. So I want a proposition that
Notwithstanding the latches,
let the latches and delay go down the drain. If a illegality is there, eternity is the time for this court to interfere with that.
well, this judgment actually says that principle only.
Bihar one. Okay.
Bihar and also this one.
Sure.
Yes. Because if it is-
say this, Pawan. And what is that citation of Bihar one?
Well, I am passing on the.
No, just give me the citation.
That
You can
is
pass it on with your arguments.
2009 5 SCC 65.
60?
5.
Party?
State of Bihar versus Upendra Narayan Singh.
Huh. I think this was also. Anything more, Mr.
No, that's all. Only one judgment I have missed out, Milord. That is also on void, Milord.
Please,
Void order, but I can, if your lordship permits me, then
you can give it to me in your written arguments.
yes. So, and on this point, Milord, coming back again, Milord, maybe for the sake of repetition.
Mr. Bhatto, the views that I'm expressing
No,
are
no,
not
Milord.
my concrete views. I'm trying to understand the matter. I just entered into a debate with you.
No, no,
That's all.
Milord, it's absolutely fine, Milord. Milord, just for the sake of, Milord,
I'm still open. I'm still
just for
open.
the sake of clarifying, Lord, as I say, that since your lordship is saying that it is whether it's a mistake or not. If because if your lordship considers the chart of events as also reproduced by them from the note sheet, everyone was conscious of the fact that what is happening on the ground. It is not that the quota was not open to them. Sorry, quota was not open to them or it was unknown to them. Even their note sheets also reveal a particular page that I had noted down, Milord. It also gives the chart of event that Anupam Das got appointed, Gagnesh Sharma got appointed.
Your this grievance, can you put it on a hold for 5 minutes? I'll give the answer to that. Let me come to Mr. Kayal. I'll give the answer to that. Yes, Mr. Roy.
I can guess, Milord, possibly what will come.
I'll come. I'm giving it to you. Yes, because that's one thing which I want to ask you.
Lordship,
Yes.
Let me clarify the promotion and the direct recruitment.
Forget.
Then, because there is a.
You put it that away. We are already clarified. You put it that in your written argument.
Okay. And then now they are saying that if the rules prescribed by law 17%, with the cadastral being 11, then the requisite number of posts will be for direct recruitment will be 2. 2 being already filled up, how can that is the question I have to meet. Lordship, kindly behave with my shortcomings, let me place it in my way, madam. Lordship, kindly take the record, madam.
Yes, page.
Page 3.
Thank you, Mr. Kayal. This is very helpful now. This is helpful. Page.
Page 3.
Page 3.
Page 2 is the after written examination, the selection process. The
Page
panel,
3. Okay.
that is the panel. At serial number 2, my client's name selected. At page 3. So this was the position obtaining. There were 6 posts of deputy director T board, the T development. And my lord will kindly see. Only the first post was for direct recruitment.
Okay.
That was occupied by Sri Gagnesh Sharma. And the rest of our promotional posts. Now the 7th post comes in. Lordship will kindly go to the footnote, my lord. Subsequently, Ministry was kind enough to consider one additional post of T-board, approval of which came during 2009, thereby making the total strength to 7. So one single post was added, my lord. So why this was added as direct recruitment, not as promotional?
Okay.
It is the policy decision of the authority.
No issue. That was what was advertised also.
Exactly.
Nobody has any grievance on that.
Exactly. So am I clear, my lord?
I got it.
Yes. Then lordship will kindly take up the page 9 by the devotion. Page 9, lordship will kindly take up of that record. I will refer to that document. Lordship kindly first read the page 9. In the file pertaining to creation of new post.
Page.
9 of the. So.
Can you also take me through page 7?
Yes, please. Temporary joining of Anupam Das, presently Assistant Director, T Development, Agartala. So the person at serial number 1, that was Mr. Anupam Das, at the relevant point of time of his selection, he was serving as the Assistant Director of T Development, Agartala.
Now, Mr. Patwari, page 3,
Yes.
the post of DR is at Siliguri. or elsewhere to be decided by the competent authority when the promotion channel opens,
Yes, true, my lord.
right?
Right.
So 2, 3, 4, 5, 6. Here they have given 6 posts.
No,
Then down below, as per SIU
yes,
recommendation,
yes, yes,
6
Big-
posts, then 1 additional post,
yes.
right?
So one additional post was given to direct recruitment.
No, we'll come to that.
Yes,
Accordingly, the considering the advertisement was of
2009.
9
Mhm.
and this notice of 2011.
Yes,
That is after the recruitment process.
yes,
So 9, they had given one at post for DR and that was put up for DR. We'll consider is that DR. Now you see, accordingly, considering the need for the post and in consultation with the foregoing, the place of posting of Mr. Anupam Das may kindly be decided by the competent authority. So that may be advised to go there. Then the question is one clear vacancy at Jorhat. So we may post Anupam Das there.
Yeah.
Since Das is a departmental candidate, now ADATT, one vacancy is to arise at Agartala. We may post the next promotee to the rank of ATDD at Agartala.
because the feeder post he will vacate.
Hmm.
That's why that was the discussion.
Okay.
Yes.
Now you come. Anupam Das was selected, has approved his place of posting at Jorhat. Meanwhile, we have appeared, reprise an appeal, requesting therein to place him preferably at Kolkata or any other place other than so and so. It is a fact that Das is out of Calcutta for a considerable period and just of appeal so and so appears to be more necessary. Therefore, may advise to join for some time. Then,
So this was regarding Mr. Das's request.
then it goes.
Yes.
Now,
Now, because there was a request by Mr. Das to place him outside Northeast Madam. So we are not concerned with that. Number of vacancy we are trying to justify. But we will kindly take up this. You see just now.
9. Okay. In the file pertaining to creation of so and so, it was decided.
But we will kindly stop there.
Hmm.
But we will kindly read the first line and for a moment. My lord. In the file pertaining to creation of new post, so there is another file where policy decision has been taken. How to fill up this post, man. Now, Lordship will kindly take up this worksheet just now. Has given. So this is dated 25th of May 2011. And my lord, I am directed to refer to T-Boss letter number so and so on the subject mentioned above and to convey the sanction of government for creation of 95 posts of small growth development directorate. So a separate directorate has been established where 95 posts were sanctioned. So out of these 95 posts, 4 posts have been earmarked for deputy.
So now 7 plus 4.
No, Lordship will kindly say. Oh, as per rules, original cadre strength is 6. The rules are annexed.
1.
1 came. So it was the policy.
7.
It was the policy decision of the government to add that single post to the direct recruitment quota. Now 4 posts are again additionally coming. So if we go by the recruitment rules, 17% or 83% of 4.
No. 83% of the cadre strength. Now cadre strength is 11.
Yes. Lordship is true. I'm not saying cadre strength.
You are saying how they have understood it.
Exactly.
They have understood it that one post is there for direct recruitment.
How? Because these 4 posts, they have applied 17 and 83%. 83% comes to 3 point, my lord, 83% of 4 is 3.32 and 17% is 0.68.
So more than 5. So they said 1.
1. So now Lordship will read this page 9. Now it will make
Now I got it.
now it will make some meaning.
Hmm.
In the file pertaining to creation of new post of small growers cell, it was decided to, in order to fill up the post of deputy director plantation, the present panel may be exhausted. Since other newly created posts of DDT are promotional and 1 left for direct recruitment, this one may be filled up by the next candidate in the existing merit panel, his choice. So this is the equation they have done.
Now the things.
And my lord, at page, running page 120 of my counter affidavit, the 2013, the revival order I have annexed,
You come to 10. Now your answer. 10.
10 of the record.
Record.
Yes. The Kamal Chandra Vaishya, Development Officer, Siliguri, has been selected candidate for the post of Deputy Director, Tea Development Plantation as a director.
Where were you finally posted? On your 11 when you were recruited? Where were you posted?
But at 11, I could not join. Immediately they withdrew me within 1 or 2 months.
You did not join.
I could not join. Joining later comes in the year 2013. That was I was
13, where did you join?
Madam Lossi will kindly come to the joining letter, madam.
You just see where you have joined.
No, they put the support. Not for now. May I just read that 2000 revival letter, madam?
No. I just want your joining place.
Yeah, I was allowed to join on board office at Agartala as deputy director.
Agar-
Page 120 of the my affidavit. in
Okay,
office.
now you read this.
Shri Kamal Chandra Vaishya, Development Officer.
You can come to the second paragraph.
This morning, the undersigned has received a fax dated 4th of July 2011 from Shri Vaishya, wherein he has accepted the offer as per terms and conditions of the board. Since Shri Vaishya is a departmental candidate, submission of forms and VR is not applicable in his case, as he has been serving the organization for more than 10 years. Now we may accept his fax, accepting the offer unconditionally, and accordingly, competent authority may be requested to finalize his place of posting. Incidentally, we have a present vacancy at Jorhat and another Siliguri, consequent upon promotion of Sri Amal Chandra Roy to the post of.
Now,
Yes.
if your appointment is against the 4 posts that has been, one of the 4 posts that has been given,
Yes.
why are they going back to the vacancies already created or posts already available with them? Why not against that small growers, tea grower, something? Why were you not posted there?
No, that small growers, it will merge with the Mahila Tea
No.
Development Board.
Merge, okay, but it will be,
Separate directorate, but it's another tea board.
let's say that 11 posts are within the tea board only.
Yes, sir.
Forget this by some
Yes.
bifurcation. Now, those posts are vacant posts.
Yes.
Not held by anybody.
Yes, it has been filled up. 95 posts has been filled up.
4 posts have to be filled up.
4 posts of deputy director has to be filled up.
These 4 posts cannot be posts which were, there were already people existing before
No.
that. So now when your posting is being considered,
True.
they need not see where the vacancy exists because you are selected against a particular post created.
True, man.
Now, why have they done this exercise? Vacancy at Jorhat, because maybe that earlier man, Anupam, he had gone away.
Yes,
So vacancy arose there.
yes, man.
And at Siliguri, consequent upon Amal Roy Chaudhary. So these are the 2 posts that have been trained. That is why he is saying that this is a promotion, not a direct recruitment. Now you got your result. So if the
Posting-
intent, no, Mr. Patwari, if you have taken me there,
Yes, yes.
if the intent is to post you against that 4 posts, one of those 4 posts, we accept that 8317 was applied there. Then also, that is not reflected here.
Yes. I don't, last occasion only I said, that
Yeah,
records
Malad,
are-
I'm sorry, Lord, if I can just indicate why I was about to, because your lordship has already brought me here. The reason is that, my lord, the projection given from the respondent side is that there was an urgent need of creating the small scale growers, etc., etc. So the posts had come and appointment had to be made. My lord, if that plea is judged against this, that falls flat.
But-
That falls flat.
That is why that day itself, this came to my notice. I did not do it because I did not go through it. I see. Yesterday night when I was thinking, this was not with me. When I was thinking, I said, how can that be? I should ask you. That is why when he came to that point, I said, you wait, I'll get a clarification. Okay, got it. Then what? Where is that 13 note, 2013 note?
page 18, my lord. And my lord, just to, my lord, point out for your lordship information. The rules of the permit, if there is no eligible candidate, the authority can place a direct recruitment candidate in a commission post.
Those are.
So things are
settled
done.
position.
Not that, my lord. some-
Now take me to that order of withdrawal.
That will be page 33.
119 of my counter affiliate matter. Running page 119. Annexure F 119. As your lordship got it. The 7th July 2000
Okay,
was
then you were given a posting order at page
withdrawn.
121,
Yes.
410. Now show me the corresponding note sheet of that.
Page 17 and 18, my lord.
That is the prior to that.
So prior to that, on 7/11, it was withdrawn.
Okay, but now where is that posting order? Where is the note sheet preceding page 121? This again is not against the small growers post. This is against an existing vacancy at out of that 7.
No, lordship has to read page 17 and 18 conjointly, my lord.
Where is this headquarter? Headquarters?
Calcutta.
Calcutta.
So before your posting to Agartala, there was no incumbent in Agartala in the post of deputy director. Yes, Mr. Doctor. Was there any incumbent in
Anupam.
Agartala?
Probably Anupam Das was, sorry, no. Before him, there was none.
None. So, Mr. Doctor, page 3 of the Mr. Patwari,
My lord.
I think this you will have to incorporate in your written argument. I'll forget others.
Yes.
In page 3,
Yes.
something in favor of an opinion in favor of Mr. Patwari. In page 3, you find the 6 posts that were there. There is no post in Agartala. Right?
Right.
7 post is also Siliguri or somewhere else. Anupam Das, gone. Jorat. Now this 4 posts that came in and his posting to Agartala is against one of those posts because earlier there was no incumbent in
Right.
Agartala. So it is this new post that has been utilized.
Maybe, my lord, but
Maybe that's something which I'm finding out. Dislodge me. Mr. Patwari, I'll forget. Put it in your written argument. What, Mr. Well,
Very close.
very bad. This is, I think, the 3rd case that I'm dealing. Not very satisfactory in your, at least in the way you manage your things. Very bad.
the problem
It
is
does
that, my
not
lord,
inspire confidence.
the problem is that they do not take his advice.
He is the firefighter.
He is the firefighter, my lord.
Lordship was
There was another case that day. I don't know what happened, whether I passed the order or somebody else I did it. That legal advisor, no, post of assistant, the
Supply
promotion,
officer.
Mr. GJ Sharma was.
Yes.
What happened finally to that?
EPC help. That thing is sent to the ministry.
But this man might have retired by now.
Yes,
But I think I provided something there.
here Lordship has provided some dates
Hmm.
within that period of probably February 21st.
Hmm.
Entire exercise will be done. That has been done and that will be sent. Now they are filing more content.
Contact.
And Lordship is kind enough to accommodate me. I have brought 3 judgments, 1 on density and 2 on several things cannot be answered. That Lordship will let me
Just
play.
put it on. What are the names?
I have already given the book list. madam.
No. You give me a written argument.
Or written, I will incorporate it.
Incorporate. Okay.
In
Now,
our-
Mr. Cal, what do you have to say?
At a copy my meeting.
Page 9 of my order. That has been
So kindly put it, or should I take it down? মই লৈ দিছো লিখাচোন এটা paragraph. Refer এইটো order নহয় দেই, just refer page 3 of the records. The breakup of the posts are given therein, and it is seen that no post of DD,
Deputy
TD.
Director, Development,
uh,
TD,
TD,
yes, double TD.
was allotted to Agartala amongst the 5 posts, amongst the 6 posts available. Also, the 7th post sanction was also considered against the direct recruitment quota with its existence proposed at Siliguri or elsewhere as decided by the competent authority. Also, subsequently, it is seen from the records, more particularly page 9, that 4 posts of DD TD bracketed plant was sanctioned for the setting up of the small growers cell. Also, 1 post out of the set 4 posts so sanctioned by applying the ratio of 83:17 as available in the rules, comma, bracket of Likiba, although the same was required to be so calculated basing on the cadre strength, bracket over, 1 post was identified for direct recruitment. Thereafter, the private respondent who was serial number 2, comma, of the select list published in pursuance to the advertisement dated dash was considered against the said post. So, it is seen that in 2011, although he was projected to be posted at Jorhat and or at Siliguri, comma, the said post admittedly figured within the 6 posts originally created and available as of 2011 in the T-board of DD TD. Also, however, the said posting did not occasion, and the private respondent was subsequently in the year 2013 on withdrawal of the revocation of his order of promotion, order of appointment, comma, posted to Agartala against the post of DD TD. So, in all probability, the post, there being no post of DD TD prior to DD TD at Agartala prior to posting of the petitioner therein, comma, the said post is to be construed to be one so sanctioned in the year May
2011.
May so sanctioned wide the communication dated 25/5/2011 marked as explicable.
No, it's already there, Miller, with the record. It's
Which-
at page,
Mr. Doctor,
108.
some convenience of the court. Just it's I might skip my notice, so I'll just take it. Okay, you give me a thing. Yes, Mr. Why this hotspots manner?
It's,
Because you have forced him, you have built a grievance in him. You could have been more appropriate, more straightforward. Nothing. If your officers are not knowing, train them or get someone from outside or ask them to take your advice. You are the standing counsel, you are entitled to make an advice.
But the projected case of the respondent and petitioner.
And what is this affidavit you have filed? If we go by the affidavit, we'll have to allow his case with cost.
in FDP.
I think it's better you don't rub it in.
It is correct, but it is not fully worded.
Not happily worded, wrong projection. And for that, what should I do? It's to mislead. You are trying to cover up something. When you could have been very straightforward, basing on your records that this is the thing that is there. We have done it. We may have committed a mistake. Delay, he goes. But now with your affidavit, he has a grievance. His grievance gets a color.
Regarding delay, we have mentioned.
Not delay, but para E and all that, A, B, C, D, E.
Lordship,
That's what I wanted you to clarify the other day.
the total strength increased to 11. With the point to put that, since the setting up the tea growers was a new challenge of the board for rendering the service of the treatment. For the sake of board's interest, the respondent number 5, it's so and so, was also on the department.
Okay. Now, you come to internal page 4 of your affidavit.
Yes,
Thus, this total sanction strength increases to 11, and as per prescribed percentage, 9 posts were required to be filled up by promotion and 2 posts by direct recruitment.
Yes.
So this is your stand. How could you have done for a third one?
no, Lordship, that was the provision for direct recruitment and
So 2 only can come in.
then.
From where has the third one now come?
No, Lordship, since the setting up the tea growers was.
That is already included there. That 11 includes the tree growers thing, small tree growers.
Probably there is a mistake in calculation.
Deliberate. You are trying to mislead this code.
No, Lordship, I sincerely, if that is so, Lordship,
Your 1, 2, 3 lines of page 4 and the rest lines are contradictory. And you come to page 5, internal page J. Show me from your records
that to the.
that the representations of 2011 was taken into consideration.
Lordship, that notice as well as because in notice,
Only the legal notice was there.
legal notice also mentioned about his.
I'm sorry. We can't draw that presumption. Because if it is 2011, why was his representation not considered then?
In 2017, his promotion, his appointment was withdrawn.
That's what, against that he made a representation.
Then after.
2 representations.
Representation.
Last is of 30/11/2013.
That is,
Therein he takes this categorical plea. You do nothing. Then some
legal notice was issued.
advice comes in. And that is done. And you take care of that. So if a legal notice can make you stand, make a change in your stand. We'll ask Mr. Doctor to issue a legal notice on behalf of his client. I think that would be more effective than a mandamus being issued from this court. We'll make some observations. So when are you submitting your return arguments?
Your lordship,
Today, next week, any day? After the Bihus, I'll pass the orders. Heard the parties at length. So, as prayed for by the Learned Council for the parties, raised it to list this matter again on before the vacations.
will it be at all necessary further listing? We can submit to the court officer.
No. I'll have to regularize it. When do you want me to? On 10th? 10th? On 10?
Just. Yes.
On 10/4/2025 to facilitate the parties to bring on record their respective written arguments along with the case laws relied upon by them in the matter. Full stop. Etu tomorrow order hobo de agor to etu just mul note ta koi thoi dile. Accordingly raised it to list this matter again for hearing and admission. Kyo dai se ji? For admissions on 10/4/2025. Then I'll fix a date. On that day, I'll deliver the order.
God bless you.
Why wait to this best? I'll be in 1970s, I found very interesting. Otherwise, the Supreme Court doesn't take any time here. Here, my lord, for the first time, we could say, if a person is agreed by promotion or anything, he ought to have salary within 6 months.
6 months,
Maximum 1 year.
1 year. That penultimate paragraph. What was the name of that case?
Yes,
Old judgment. I think it's on the
1970 probably.
yes.
left-hand side. Last page, left-hand side, one paragraph.
Third judgment.
Hmm. Okay, you can give it to Mr. Dotto.
Yes,
You can take this, you can give it to me with your written argument.
Nothing can period.
It's on the left side.
Mark to mark. The mark to mark. I'll take it.
Sadasuro. Sadasuro. And this has been referred in subsequent judgments also.
Not that the High Court doesn't have power, but still.
This judgment I'll never forget. I was having a very, my Lord Justice Nishit Chaudhary's court, a review I had filed. I was with him, he was with me. The senior advocate Diganta Das. He placed this judgment. My whole case collapsed. I still remember Justice Chaudhary giving that normal thing. Aha. Got it.
That's how we like.
And I learned it the hard way.
Deeply obliged.
Thank you.
Obliging.
Much obliged.